Coffin lecture on law and public service. This lecture has always been one of the highlights of the academic year at the University of Maine Law School, and it is also an honor personally for me to have the opportunity to meet and to present to you our distinguished lecturer, the Honorable Cruz Reynoso, and also to introduce Judge Frank M. Coffin, the distinguished jurist and public servant for whom this lecture is named. We are also pleased this evening to welcome members of Judge Coffin's family, Mrs. Ruth Coffin, Judge Coffin's wife, well, not obviously, obvious to me. I guess I'm behind the times. Their children, Meredith, Nancy, Susan, and Douglas, and also to welcome the many of Judge Coffin's clerks who, as a group, have been so instrumental in making this lecture series a reality. The University of Maine School of Law takes great pride in its sponsorship of this annual lecture. The lecture reflects and celebrates the law school's strong and abiding commitment to public service and challenges us to consider new ways to ensure that the law and the legal profession continue to serve the public good. Since its inception in 1992, the Coffin Lecture has brought to our community a brilliant array of extraordinarily talented and thoughtful individuals. Each of our 10 previous Coffin lecturers, who are listed on the back of your program, has challenged us to reflect in new ways upon the powerful intersection of law and public service. And there is no doubt whatsoever that Justice Reynoso will continue in that fine tradition. As Judge Coffin and I have traditionally divided our responsibilities, I'm to provide you with the biographical introduction of our lecturer, and Judge Coffin will characteristically provide the extra measure of depth and insight. The Coffin lecturers are selected by a committee composed of faculty, students, and former clerks of Judge Coffin. The committee looks for individuals who are exemplars of a life devoted to law and to dedicated public service. Justice Cruz Reynoso is indeed such an exemplar. His career has blended law and public service in a variety of contexts: in the private practice of law, in government service, in the legal services movement, and in academia. A graduate of Pomona College and the University of California at Berkeley Law School, Justice Reynoso began his legal career in private practice in El Centro, California. In the mid-1960s, he responded to the call to government service, serving first as Assistant Director of the California Fair Employment Practices Commission and subsequently as Associate General Counsel of the U.S. Equal Employment Opportunity Commission in Washington, D.C. In 1968, Justice Reynoso returned to his home state to lead California Rural Legal Assistance, one of the pioneering programs in the legal services movement. It is no exaggeration to say that his work there on behalf of farm workers and other low-income and unrepresented people is legendary, and he remains a revered figure in the legal services community. Justice Reynoso left the organization in 1972 to join the faculty of the University of New Mexico School of Law, where he continued to explore and be a leader on issues of civil rights, educational equity, and legal services to the indigent. His academic career was interrupted 4 years later by his appointment by the late Governor Pat Brown to the California Court of Appeal. He served on that court for nearly 6 years before being elevated to the California Supreme Court in 1982. The son of Mexican immigrants, Justice Reynoso was the very first Hispanic American to serve on California's highest court. He left the Supreme Court in 1987 and once again entered private practice as special counsel to the K. Scholler law firm. In 1999, he returned to academia, joining the faculty of UCLA Law School. While at UCLA, he was appointed to the United States Civil Rights Commission, of which he has been vice chair since 1994. Last year, Justice Reynoso was named the inaugural holder of the Boocheever and Bird Chair for the Study and Teaching of Freedom and Equality at the University of California, Davis Law School, where he continues to pursue his academic interests in responsibility, civil rights, remedies, and appellate advocacy. Over the years, Justice Reynoso has received numerous honors and awards, including in the year 2000 alone, the Presidential Medal of Freedom, our nation's highest civilian honor, and the Hispanic Heritage Foundation Award in Education. He holds honorary degrees from many colleges and universities, including his alma mater, Pomona College, the University of Santa Clara, DePaul University, and the University of San Diego. The real introduction of Justice Reynoso, the one that enlightens and deepens our understanding, will be given, as it is always, by another exemplar of a life devoted to law and public service, the individual for whom this lecture is named, the Honorable Frank M. Coffin. Judge Coffin is one, especially for our students who are less familiar with him now, but will know him better as they go through school. He is one of the rare breed of public servant, one who has served with distinction in all three branches of government, as a United States Congressman, in the executive branch as Deputy Administrator of AID, the Agency for International Development, and in the judiciary. First appointed to the U.S. Court of Appeals for the First Circuit in 1965, he served as its Chief Judge from 1972 to 1983. In 1989, he assumed senior status on the court, but as all of us who know him well know, he has not slowed down. In addition to hearing cases, he has continued to write books, working on his memoirs as we speak. Not right here, but we will certainly be part of your memoirs, I am sure. And more importantly, has given generously of his time and prestige to ensure access to justice for all citizens. Currently, he is at work on another project, serving as co-chair of the ABA's Commission on Loan Repayment and Assistance, which is trying to grapple with the difficult issue of law student debt and its effect on the ability of law graduates to enter careers in public service. A graduate of Bates College and the Harvard Law School, Judge Coffin is the author of 4 books and numerous articles. He holds honorary degrees from Bates, Colby, Bowdoin, and the University of Maine. He is revered by those who practiced before him and commands the respect and lifelong affection of his law clerks, the law faculty and staff, and all those who have worked with him. Last year, Judge Coffin was the recipient of the most prestigious award that a federal judge can receive, the Edward J. Devin Award for Distinguished Service to Justice. Although a graduate of that other law school down in Cambridge, Judge Coffin has been a wonderful friend to Maine law, supporting and guiding us and our students in many ways for many years. As I have said before at this gathering and elsewhere, one of the greatest pleasures of my deanship has been the opportunity to work with Judge Coffin and to see this man in action. And I'm especially delighted this evening to announce a development that will deepen and extend the law school's relationship with Judge Coffin for many years to come. Because the judge has honored us by his decision to give his judicial papers to the law school and to our Garber Law Library, where they will be maintained and made available for use by scholars and students for generations to come. It's a wonderful gift indeed, for which we are deeply grateful. Brilliant lawyer and public servant, Judge Coffin is also an accomplished artist. In fact, some of us tried to persuade him this year to allow us to display some of his wonderful sculptures at the reception immediately preceding this lecture. With his characteristic modesty, Judge Coffin declined our entreaties, but that effort did give me an idea. For a more appropriate metaphor, some of you may know that Dean Zillman and I have used sports metaphors for years as we've thought to figure out a way to capture Judge Coffin's place in the legal firmament. So now I have a new idea. It is with great pleasure that I present to you the Michelangelo of the federal
God, the metaphor has changed. I can deal with Michelangelo much better than with baseball.
That's true.
This is a wonderful evening, and I'm so delighted to be here. And thank you for your warm reception to us. Now, as you heard from Dean Corey, our guest speaker, he doesn't just have a curriculum vitae, he really has a college catalog behind him. He's been an activist. He really combines all of our prior lectures. He's been an activist, he's been a professor, he's been a judge, and he's been everything except perhaps what Warren Ruttman was, a senator. But his first job following law school was to work for a senator in the California Senate, so that's a little bit. And anyhow, Warren Ruttman isn't a Hispanic American. But wondering just how I could deal with this sparkling collection of positions, honors, and achievements that Dean Corey has summarized, I finally decided to explore a time just before eminence settled upon Justice Reynoso, a time of testing which reveals the mettle of the man. This is also the story of Justice Reynoso's first encounter with a judge from Maine. In 1968, at age 37, young Cruz Reynoso, after some years in California state government, was named director of the newly founded California Rural Legal Assistance Agency. CRLA was founded in 1966, the first rural legal assistance program of the Office of Economic Opportunities, War on Poverty. In CLRA's case, war was an appropriate word, for it represented poor and vulnerable farm workers against the entrenched, powerful farm owners, their lawyers, and government officials. They had offices in about 10 cities throughout this immense state. The pot boiled over when CLRA won 12 out of 13 appeals in welfare cases, and even brought suit against Governor Reagan. Opposition quickly galvanized. A John Burke Society dedicated opponent, Louis Bueller, as it happens, a classmate of Justice Reynoso's at Old became director of California's OEO office for the specific purpose of putting CLRA out of business. He began an investigation and issued a 283-page report levying 127 charges against him, ranging from helping Angela Davis without authority to inciting inmates of prisons to murder their guards. I think there was one charge that a lawyer even went barefoot to court. Late in 1970, acting on this report, Governor Reagan, as was his authority at the time, vetoed CLRA's funding for 1971. The veto could be overridden only by the national head of OEO, Frank Carlucci, who had just succeeded a man bearing the faintly familiar name of Donald Rumsfeld. The American Bar Association, strongly supporting CLRA, called for a widely representative commission to investigate the charges. Bar people, public defenders, congressional appointed people, very widely representative group. But President Nixon, anxious to avoid confrontation with Governor Reagan, who was looking over his shoulder very closely, resorted to a safer bet, a commission composed not of federal judges who couldn't be trusted, but of state Supreme Court justices, all Republicans. The chair was a recently retired Chief Justice from Maine, Robert Williamson. Chief Justice Williamson's special aide was young Portland lawyer Peter Murray. Despite considerable controversy and the urging of Vice President Agnew to recall the commissioners, the commission set about its business. For 6 weeks in the spring of '71, the commission held 20 days of hearings throughout the state, hearing 165 witnesses, often working in windowless rooms. And of course, a key witness in these proceedings was Cruz Reynoso, the director of CLRA, on whose watch this drama had unfolded. Tempers were running high. The office of a lawyer had been firebombed. Peter Murray recalls that at Salinas, just inland from Monterey, pickets paraded outside the city council chamber. The crowd was rested, and inside the hearing room, they had become truly unruly. The storm was brewing. Then the panel entered, and Chief Justice Williamson sat down, knocked gently on the table, and said, "Here, here, we'll have none of that." But he didn't. Oh, marvelous. Hasn't been done since. By late spring, the press had become critical of both Eula and Governor Reagan. Support had been building from the grassroots, the bar, and from both sides of the aisle in Congress. A particularly appreciated support was a letter from Senator Margaret Chase Smith to both the President and Carlucci, chastising anyone who would challenge the fairness of Chief Justice Williamson. Well, finally the report was prepared. It dealt with all the charges, declared them unfounded, and condemned the Eula report as totally irresponsible. It found that CLRA had carried out its duties in a highly competent, efficient, and exemplary manner. To assure OEO Director Carlucci enough time to study the report before acting, Peter Murray flew east and delivered it personally. The commission followed and waited several days. Nothing happened. But eventually, when it appeared, wrongly, it later developed, that the New York Times had the story, the report was allowed to enter the public domain. The refunding of CLRA quickly was confirmed as a face saver for Governor Reagan. The administration gave him a grant for a Judicare project, which proved to have a short life. And so Cruz Reynoso, following the hard way, won vindication of his earliest major responsibility. And Chief Justice Williamson would be the first to celebrate his visit to a state which was among the first to appreciate him. It is my happy privilege to present the 11th Coffin lecturer, a man of many parts, the Honorable Cruz Reynoso.
Thank you very much. What wonderful introductions from both of you. And I should tell you that I've had the pleasure of visiting with the judge and his family at his home. And one of the things we were doing was watching some old tapes, 30 years old, about CRLA. And I was being reminded of much of what happened during that time. So I have very much appreciated. For me, it's a great honor, I must say, to be here before you in a lecture named after the judge, and particularly a lecture that bases its foundation on public service, because public service for lawyers and for the law is really so important. Indeed, public service should simply be part of what we as lawyers do and simply accepted as part of our profession. But when I came here, I should tell you that I brought greetings for the judge. I brought greetings from the immediate past president of the American Bar Association, who's here from Maine. Though I should tell some of you law students that he won his campaign on a campaign motto that said the ABA should have a president from Maine at least every 100 years. So some of you who hope to be president of the ABA might have to wait a long time. And then I brought greetings from two of my colleagues at the University of California, Davis, who had worked with the judge, and the colleagues refer to themselves as the Davis Fan Club. So the judge has had many folk with whom he has shared his life over the years. But to me too, it's so important that I'm going to talk about the concept of public citizen because it's part of our ethical obligation. But to me, the judge really represents the epitome of a lawyer as a public citizen. He's been a lawyer, as we know, a legislator, a federal administrator, a judge, a man of letters, and always gentlemanly and gracious. And I didn't know until today that he was also an artist. And I must say that I was considering being an artist before I went to law school, so we're apparently comrades in arms. And to me, this lecture on a lawyer as a public citizen is really an extension, I think, of the life of Judge Coffin, what his life has been about. I was interested, as I indicated, in the role of a lawyer as a public citizen because, among other things, I teach professional responsibility, legal ethics. And I want to read to you the first sentence of the preamble of the ABA's rules of professional conduct that's entitled A Lawyer's Responsibilities. And this is what it says. These are our obligations. A lawyer is a representative of clients. We know about that. We deal with that as lawyers every day. We're quite conscious of our ethical responsibilities in terms of our clients. Then it says, an officer of the legal system, and we're aware of that too. At least I thought I was aware of our responsibility as being officers of the court, because we're supposed to be courteous, and we're supposed to be on time in filing our briefs, and we're supposed to respect the court. In California, there was a case in which a lawyer said some not very nice things about a federal district court judge, referred him as a racist and all kinds of things, and the judge referred the lawyer to a committee who then studied the case and recommended that he be suspended from practicing before the federal courts for 6 months or a year. The lawyer appealed to the Ninth Circuit, and the Ninth Circuit said, not just paraphrase, they said, hey, wait a minute. A lawyer ought to be free to say anything he or she wants, and it only ought to impinge upon judges if they can be intimidated. Who can intimidate us? We sit to the right hand of God, and they reverse the order. So now I'm not quite sure what being an officer of the court means, because I always thought we should be courteous as lawyers and respectful, but apparently now at least the Ninth Circuit says not so. But I hope that's an exception. I still take seriously our ethical responsibility to be an officer of the legal system. And then it says, and we don't pay much attention to this, and it's a matter of my great interest, an ethical responsibility is to be a public citizen having special responsibility for the quality of justice. And so I asked myself, what does that mean? What does it mean to be a public citizen? Not as a lawyer, but also as a public citizen seeking after the quality of justice. And so I did some checking, and I thought surely the QTAC committee, which put together the recommendations for the current rules of ethics, will have a whole essay about what a public citizen is. And so we looked it up, as some of you who study ethics may know. The report was circulated in 1980, adopted by the ABA in 1983. I looked up the report. How much does it have on the duties of a lawyer as a public citizen? 0. So wait a minute, this notion must come from somewhere. So I started reading more in the background. And of course, the ABA first issued its first, what it called Canons of Ethics in 1908. And most of the authors agree that it took its emphasis from rules of ethics that had been issued by the state of Alabama in 1887. And so then I went back and took a look at the rules of ethics issued by Alabama in 1887, and it's quite fascinating. It was codified, and I just want to bring you a couple of their rules, and then tell you what California says. For example, rule number 7, seventh rule of the rules of ethics in Alabama, passed in 1887, says that it's an ethical rule of a lawyer never to reject for any consideration personal to themselves the cause of the defenseless and oppressed, a high ideal for lawyers that we ought to take seriously. We have in California the Business and Professional Code 6068. Subsection H reads like this: never to reject for any consideration personal to himself or herself the cause of the defenseless or the oppressed. The legislature went back a few years ago and added herself to the statute, recognizing there were beginning to be a few women that were in the profession. But notice how it's practically the same wording. So what Alabama did in 1887 still has an effect today. And then I'll read you the whole 5th rule of ethics from 1887. To abstain from all offensive personalities, which obviously that lawyer I mentioned to you didn't do, and to advance no fact prejudicial to the honor or reputation of a party or a witness unless required by the justice of the cause with which they are charged. Then listen to the rule, professional responsibility, again in Business and Professional Code 6068 in California, to abstain from all offensive personality, and to advance no fact prejudicial to the honor or reputation of a party or witness unless required by the justice of the cause with which he or she is in charge. Practically the same wording. Now I must tell you that I was delivering a lecture one time before lawyers, and I read them this code section in California, which says to abstain from offensive personality. And apparently the lawyers hadn't paid much attention to that because they started laughing. And I said, what's so funny? And they say, half the lawyers in California would have to be disbarred if they have to be nice all the time. But this really, I don't think it means that they have to be nice all the time, but we really ought to be courteous and respectful to one another as lawyers, and of course to the bench. I mentioned that to you because the code writers in Alabama, in turn, gave credit to Judge Sharswood, who had practiced in the before and was a chief judge of the Pennsylvania Supreme Court. He had written an essay on legal ethics, and I actually brought the little booklet with me. Wrote it in the 1850s, rewrote it 3 or 4 times, finally, and published several times, the last time in the 1890s. And the Alabama Code cites the judge and quotes from him. And I just want to read to you a couple of things that he wrote, so you can see that this notion of a lawyer as a public citizen, I think, starts taking hold, I'm sure way before, because Judge Sharswood was putting down in black and white what he thought were the proper ethical obligations of a lawyer. And this is the way his book begins. Professional ethics. It is proposed to consider this subject under 2 general heads. 1, the duties which the lawyer owes to the public or commonwealth. Now notice he starts out in terms of the ethical obligation of a lawyer, not to the client, but the obligation that is owed to the public and the commonwealth. Then he goes on to say, the second one is the ethical obligation to those who are due from him to the court, his professional brethren, and his client. So I think we start to see that these notions are not new notions, and yet, and we now find it in our ethical obligation. Then he begins his essay as follows. The dignity and importance of the profession of law, in a public point of view, can hardly be overestimated. It is in relations to society at large that it is proposed to consider it. This may be done by showing its influence upon legislation and jurisprudence. These are the right and the left hands of government in carrying out the great purposes of society. And he adds, the proposition would be still more accurate where it said, society is constituted that men may be free to develop themselves, free to seek their own happiness, follow their own instincts or conclusions. Without society and government, which of course results from it, men would not be free. So these concepts, these ideals, are deeply embedded in the ethical responsibilities of the lawyer. Now, as I indicated, Judge Sharman wrote it in the late 1850s. A little bit before then, de Tocqueville, you remember, had traveled in this country in the 1830s, if I remember correctly. And I want to read you something that he wrote that sounds, frankly, a little bit strange now, but an indication of the responsibility the lawyers have and the responsibilities we can have. This is what de Tocqueville wrote. In America, the lawyers formed a political upper class and the most intellectual section of society. It is at the bar or the bench that the American aristocracy is found. When the American people let themselves get intoxicated by their passions or carried away by their ideas, the lawyers apply an almost invisible brake which slows them down. Lawyers, forming the only enlightened class not distrusted by the people, are naturally called upon to fill most public functions. And I'm sure it's those notions that de Tocqueville had observed in America that these ethical rules picked up on. The ABA itself didn't start writing these rules until 1908, as I indicated. But you know, the ideals that we have and the reality that we have don't always jive. In modern history, for example, it was mentioned that when legal services came under attack, the American Bar Association came to its defense. The California Bar Association came to its defense, but it was not always true. When the California Rural Legal Assistance Program was first formed, and it had the various offices because we represented farm workers and migratory farm workers. So we needed to have offices from as far south as El Centro, which is the southeastern desert area of California, but a rich agricultural area where we get many of our winter crops, including lettuce. You probably eat Imperial County lettuce out there during the winter. And up to the north, going up to Marysville and cities in the north. The California State Bar opposed the establishment of that program and sent telegrams after a vote. They were tied to, at that time, the notion that each county should have a legal aid office, and we were going to go beyond one county. They thought that was a no-no, and so they opposed it. Also, of course, as you know, in 1908, when the ABA issued these rules of ethics that sound so grand, it did not permit African Americans to be members of the bar. So sometimes we have these great ideals, but then we have to work to make the reality fit those ideals. When we established an office for legal services in Imperial County, some lawyers objected to it. They said that no poor person in Imperial County had ever gone unrepresented by a lawyer. And I believed that they believed that was true. I knew that it was different. In fact, when I joined the bar, it was 1959. How many of you are older? How many of you were alive in 1959? Not many of you. These are not the students. Anyway, I went down there, and at my very first bar meeting, I was elected secretary of the bar. I thought, hey, that's pretty good for a young lawyer. I didn't realize there was a tradition in Imperial County of naming any new lawyer as secretary, because it was the secretary that did all the work for the local bar. But one of my jobs also was to refer folk who needed legal services to lawyers who had agreed to interview them and charge just $5 or $10 at that time. I received calls from a nearby military establishment, and so then I would try to refer those potential clients to lawyers. Sadly, I've got to report to you that most of the lawyers were always too busy. There were just 2 other lawyers who accepted those cases. One was a very socially conscious lawyer. The other one was the immediate past secretary who understood the problems I was having. And yours truly. We were the only ones who would interview those sailors, they were, believe it or not, sailors from the desert, and try to respond to their legal needs. So I became very sure so quickly, and indeed, just when the folk came to see me, there were many poor people who were not receiving legal services. After the office was established in El Centro, we established it with 1 lawyer. There was a greater need, and we fortunately had more lawyers, so we sent a 2nd lawyer. Then we sent a 3rd lawyer. Then we sent a 4th lawyer. There were 4 lawyers doing nothing but representing poor people in Imperial County, and they had to set up a priority of cases they would take because they couldn't take all the cases for poor people. That's how divorced we can get, I think, from the reality, even though we live there and we think we know what the reality is. And so we have to be, I think, concerned about making sure that we understand that reality. Consider Alabama in 1887. The days of Jim Crow. Nearly 50% of the population was black at that time. They couldn't go to school there. We had a labor code that if you had a contract to perform labor, it was unlawful to leave that contract, and you could be arrested. And there were laws that permitted the arrest of anybody for loitering, and that was at the judgment of the local peace officer, and a disproportionately large number of African Americans ended up being arrested. When they got arrested, then a fine was imposed. If they couldn't pay the fine, a sentence was imposed. Then they could be sold to private individuals who would employ them if they would pay the fine. I read about one case where several teenagers were arrested, put in jail. They were fined $6.50 or 4.5 months in jail. They couldn't pay the money. They were sent to jail, and then a person came and bought them for $40. And then they had to work for that employer for those 4.5 months, for example. There was a whole mechanism in society, basically to keep blacks from fully participating in the society of Alabama. At the same time, we had this wonderful code of ethics for lawyers that says that they had a responsibility to be public citizens to seek after justice. So it seems to me that we have to keep in mind that even though we may have these great ideals, we've got to look at reality in its face and say, are we meeting those ideals? And you know, it's easy for anybody, and we lawyers are privileged, it's easy for anybody who is in a privileged position, it seems to me, to forget that they are so privileged. I read an article the other day asking the question, why titans fall? And I was talking about CEOs. You know, we've had a few problems with CEOs lately. And they gave several reasons. I'll just mention 4 of them to you. These are the reasons why titans fall. Quote, I deserve it. That is, a person gets into that position, and the person starts telling himself or herself, I deserve it. I've worked hard all my life. Why shouldn't I take home a few $10 or $20 million a month? I mean, it's only natural. Second reason, society's blessings. That's not important. People look at the CEOs and say, gee, you're so important, you're such a wonderful person, and the person starts believing it. Society's blessings. 4, competitiveness gone awry. And I must say that even in the bar, we need to think about that. And the last one was, that I mentioned to you, there were several others, power corrupts. You have a lot of power, you start being a little bit careless with how you use that power. And we have, any of us who are in a profession have to keep that in mind. Or in the medical profession, I was looking and reading a book called Blind Eye about Dr. Michael Slagle. You might have read about that doctor who went to Ohio State and became a doctor there. And sad to say, he was a sick man, and he killed people. And eventually the FBI thinks that he may have killed 60 patients. But every time that something suspicious happened, for example in Ohio State, he injected some people improperly, 3 employees saw him do that. They reported it to to the medical staff. He denied it. The medical staff quickly accepted what he said, did not accept what the other witnesses said. But I can see what they were thinking. What happens? What will we do to the reputation of the hospital if we let it out that a doctor's doing terrible things? I mean, I can see how they were thinking. The reality was that they didn't report him. He went out to work in other hospitals, and at least now is sort of firmly believed that he ended up killing at least 60 people. So we have to look at the ideals that we have. We have to look at the ideals of a lawyer as a public citizen, but then we have to look at where the reality lies. Now, I must say that in thinking about this, I've come up with at least 4 notions of what it means to be a public citizen. And this, remember, is our ethical responsibility. And obviously, my notions are based on my own experience. First, I think a public citizen, in part, that role is related to his or her role as a lawyer representing clients and his lawyer as an officer of the court. It's not unrelated from that. I don't think a lawyer can be a good public citizen without being a good lawyer, without being an honorable lawyer, without doing what's right in his or her profession. So we look at what lawyers do. I know that there's been, I've chatted with several folk, including the judge, about the great work that's being done in this state in terms of pro bono. That's simply the work that you do as lawyers, but it's also part of being a public citizen. And there's been talk, not enough thinking yet, I don't think, about reduced fee programs. But I think we ought to think about that in terms of the type of work that we should do. So often we get folk in our offices who don't have money, and we need to analyze whether it's best to provide that for free or best to charge a little bit of money. I recall I hadn't been a lawyer in Imperial County too long when a couple of retired farm workers came to see me. Now, retired, you understand, doesn't mean they had a pension or anything like that. It meant they were too old to work in the fields anymore. And they came to see me because they had no resources. And they wondered whether there were any programs that could help them. And the lady who came in had a goiter condition. I don't know if you've ever seen a goiter condition. She had a big growth under her chin, and she had open sores on her legs. The gentleman, we found out later, was legally blind. That is, he had a visual rate of less than 20/200. They came to see me, and I told them that I would try to help them. At that time, the regulations by welfare departments weren't kept up very well. And I told them, look, I'll see whether or not I can help you. If I can help you, I'll charge you $100, and you can pay it off at $5 a month. If I can't help you, I won't charge you anything. And fortunately, I ran into a welfare worker that was just a wonderful woman, and she helped me go through all of those dusty regulations and so on. And we eventually found that at that time, California had a program where they had where they actually had not Social Security for those who didn't have Social Security, and some farmers that did not. They had a pension for older people, not a lot of money, but some, and they were both entitled to a small pension. He, because he was blind, was entitled to a second pension, and they were entitled to medical attention in the local county hospital. So her goiter was operated on, her legs were taken care of, and they had a few dollars coming in each month. My wife and I visited their home. Their home didn't have a floor. It was dirt. They didn't have any running water. They had to walk like a block away to a faucet to get running water. They were pretty poor. But at least with a few dollars a month coming in to their home, they were able to live with some dignity. And by golly, so I was able to help them. And by golly, every month they'd come in and pay the $5. And I can't tell you how many people came to see me, new clients came to see me, and they say, well, Mr. So-and-so recommended we come to see their lawyer. I became their lawyer. And I don't know how many clients I got. But you know, it's funny that even though I was a legal services lawyer, I think that whenever appropriate, it's good to charge something to the client, because the client then becomes more involved in the case. I remember representing some groups in political matters, and I remember one group particularly, they retained me to represent them, retained me on a pro bono basis. I testified for them, I organized and all that. In a couple of years, they seemed to have lost interest. Said, who are my clients now? And I think if I had charged them, even at that time, $5 or $10 a month, they probably would have been more interested. So I can't help but think of those experiences as I think of the lawyer as a public citizen, as a lawyer. Then let me tell you about Nancy Minty. Nancy Minty is a graduate of UCLA. When she graduated, she wanted to represent poor people, and I mean really poor people. She thought that the people who needed representation were the homeless people in downtown Los Angeles. A good person loaned her a garage, and her office at her home was in that garage. And she started representing poor people in downtown Los Angeles when they had problems with Social Security, when they had problems with housing, and so on. And she said she had no money, and the only little money that she would get was if under those regulations she could probably get some money from the government, but that's what she did. Then she said she was visited one time by a lawyer who went to visit her in his three-piece suit. And she looked up rather suspiciously, saying, who is this guy who's coming to see me, probably to scold me? And this gentleman said, I've heard about the work that you're doing here, about the great work that you're doing, and I'm just here to ask you how I can help. He happened to be a partner in a large downtown firm, very well connected. So once she got over her suspicion of him, they had a good long talk, and by golly, he went out, and before you knew it, he had persuaded several foundations to contribute money. Many lawyers were helping her on a pro bono basis. Now they have a foundation with several lawyers representing the downtown poor people of Los Angeles City. And so I just can't help but think of her as a person who combined being a public citizen with being a lawyer. Or for that matter, all we can think of prosecutors who have the role of protecting us, and the most important role that government has is to protect our own safety. They surely are operating both as lawyers and public citizens, or defenders, whose role it is that if government is going to take somebody's freedom away, it has to be done constitutionally and legally. Surely they are performing great public service as public citizens and as lawyers. So I don't want to divorce, in my first point, the role of a lawyer from being a public citizen. But it goes beyond that, I think. I think the second duty of a lawyer as a public citizen is to work within the bar associations. And again, progress comes. I didn't join the American Bar Association for many years because of what I considered as racist background. In 1972, an African-American lawyer, an appellate lawyer from San Francisco, called me and said, Cruz, would you be willing to serve on the section on individual rights and responsibilities? And I said, I don't know, but what do I have to do? He says, you've got to join the ABA. And I said, I'll never join the ABA. They wouldn't allow blacks to be members, etc. And he says, no, Cruz, things have changed. He says, I'm a member of the ABA. And he told me some of the things that were going on. And so I did join the ABA, and I've been a proud member since that time. But look at the changes in the ABA. From a time when it was a racist organization, a time that it opposed programs of legal services and so on, to a time that it's the champion of integration. It's got the committees working on making the legal profession more representative by ethnicity and race and gender and so on, and it's great support for legal services. It's in my view, a great organization, but it's taken a lot of work by lawyers, good-thinking lawyers working within the bar associations to bring it about. Or I mentioned the California Bar, where they opposed the establishment of CRLA, and we entered into a compromise. Lawyers always compromise, right? Not always, but if you can, it's good to mediate. I'm a mediator. We entered into an agreement with the bar that they would name 2 members of the Board of Governors of the bar to the board of CRLA. They were supposed to be there as watchdogs. But after being on the board for only a few months, they became our strongest supporters. And I think that was not unimportant in having the bar in California going from opposing the establishment of CRLA to again becoming one of the greatest supporters for legal services programs. And now they have a program for pro bono work. They have a program for legal services programs, and just have been a real source of strength. And I should tell you that I was so proud of our country when we as a country decided to establish the legal services program, it seemed to me that that was the next great step that we took after deciding that folk who were accused of crimes were entitled to legal assistance. Because it was a great step forward in, again, getting our country a bit closer to those ideals of true equality and representation in our courts. Even today, we have problems in the legal profession. You know, I think we still have to think hard. I don't think that the legal profession is yet as gender-friendly, or let me say female-friendly, as it should be. I don't know how many women I've known who've either quit their firms or gone into very part-time because they have other responsibilities. And I've heard, fortunately, some women lawyers from the ABA speak eloquently about the reality that the bar has to become more friendly to all of us, male and female. We are not yet representative of the various groups, ethnic and racial groups in this country. In California, Latinos now are 35% of the people and only 3% of the bar. African Americans are about 9% of the people, about 2.5% of the bar. Asians are about 11% of the people of California, about 3% of the bar. We've got a long ways to go, but the ABA has been working on those issues. So there are issues to be worked on, and there are issues that hopefully have already been solved. So my second point is that we need to work within the bar. The third, and I think perhaps, to me, perhaps the most important one, is that we have as lawyers to work beyond the bar. To be public citizens, it seems to me, is to lead a life like the life of Judge Coffin, where you work before the public. To be elected officials, for example, I think we have a duty for those of us who have an interest in politics to run for public office. I tell everybody that they ought to run for public office at least once, because I ran for public office once, and I thought I knew the area in which I lived. But I must tell you that I met so many people that I didn't know, so many organizations, so many interests. Now, I do tell them that if they're lucky, they'll lose, but if they win, they will go on and serve in Congress and their local legislators. I was lucky I lost. But it's such a learning experience. Then I must mention to you that countless mayors that I talk to who tell me that they appoint judges to special commissions, the Water Commission, the Police Commission, and so on. The lawyers will accept the positions, then after a year or two they will quit and say, gee, I just don't have time anymore. It seems to me that as public citizens, we have an ethical duty to make time. And I've always believed in a balanced life. I think we have to take a little bit of time for art. I think we have to take a lot of time to read non-legal books. I think we have to take time with our families, certainly with our profession. But we also have to keep part of ourselves for the public weal. And we as lawyers, I think, are special people that know better than most the relationship of government to citizen and to resident. So I think we have a special responsibility when called upon by elected officials to participate in government to do so. And then I just think we have a duty to be part of the political system. I heard a tape the other day by a lawyer from Mississippi. He represents plaintiffs in personal injury and civil rights cases. And in his talk, he was talking mostly to defense attorneys. He was telling about the folk he represented and how often the Fifth Circuit overturned jury decisions. With their conclusion, there was an issue of law, not an issue of fact. I know all of you students know about that. He said that, I think he said 49% of all of the cases that were appealed, that were jury cases, were overturned by the Fifth Circuit. Of course, as you might imagine, he was being critical of the Fifth Circuit. But he said, you notice that every opinion that comes down by a judge of the Fifth Circuit that's favorable to the jury is a judge who has had those interests before being on the bench. You're influenced by who you are. And every opinion that's written by judges that seem to be antagonistic to the jury seem to come from another walk of life. So he was saying that politics is so involved with the administration of justice that we as lawyers indeed have a duty to participate in that political system. And I must say that I consider that part of our responsibility as public citizens. And then, and importantly, it's to be part of community organizations. And I want to emphasize that, community organizations, not legal organizations. And I've been pleased and saddened by an evolution. When I became a lawyer, and I was particularly conscious in California of the Latino community, there could have been more lawyers than I could count in the fingers of my 2 or 3 of my hands. Maybe 2 dozen Latino lawyers in the whole state. But all of them were very active in the community. Nowadays, we have several thousand Latino lawyers. But I should tell you, if 10% are really active in the community with community groups, I'd be pleased and surprised. So we have greater numbers, but I'm not sure that in percentage, lawyers are now as involved as they were many years ago in being members of non-lawyer groups. Thus, for example, I was asked to join, and I did join a group called Community Service Organization. I was telling the judge that I knew Cesar Chavez before he started organizing farm workers, and I knew him in the CSO. He was a staff person for the CSO. And what did we do in the CSO? It was mostly poor people that belonged to it, and mostly people who lived in what was called the east side of El Centro, principally Latino and African Americans, but a few Anglos also. And we had English classes for the immigrants who wanted to learn English. We had citizenship classes for those who wanted to become citizens, and we urged them to become citizens. There was the people in the east side of El Centro complained because they didn't have sidewalks and curbs, and even in the desert it rains. I understand it rains here too. But even in the desert it rains and it gets muddy, and they thought that downtown, the city officials had no interest in their community because it was poor and minority. But I was a member, and they told me about that complaint, and in the back of my mind there was something that told me that in fact there was a legal response to that. And so I went to talk to the officials, and sure enough, there was an old statute that permitted a locale to form a special district where they could tax themselves. And by taxing themselves, they could have the city indeed fix the streets and put in sidewalks and curbs, and they were so interested in doing that they were willing to do that. The city, in turn, was so pleased to have these citizens come forward that it agreed to pay all of the legal costs of setting up the district and agreed to pay 50% of the cost of building the sidewalks and curbs and so on. And I remember thinking to myself, if I as a lawyer had not been a member of this group, a group of non-lawyers, they still would have been disenchanted and angry at the politicians, not knowing that in fact there could be a resolution to the problem that was hurting them a lot. But a lawyer won't know that of poor people and community people unless they're part of the community. And I think we need to remember that to be public citizens, we need to be members of the committee, whether it's working with the Boy Scouts or the FFA or 4-H that my children were involved in, being a member of the board of the National Resources Defense Council, as I am, working on matters for the environment, working on with the local PTA, whatever. We ought to be part of the community, and then from time to time, not always, and I tell young lawyers, look, if you're appointed to a housing commission, about 90% of the work you'll do will be absolutely boring. And you'll be there voting on things that you don't think are important, but from time to time, that important issue comes up. And you can really do good by being there, having done your homework, and not be a newcomer to that board. And at that time, do what's right by the community, what's right by justice, exercising what I feel is your public responsibility to be a public citizen. So I think it's very important for us to be involved with non-legal groups. Then my fourth point is this: I have a duty to speak out, even in hard times. I was a young man during the McCarthy era, and since I was always in favor of civil rights, I can't help but remember the attacks that folk who believed in civil rights came under during those times. Often accused of being communist. Martin Luther King was often accused of being a communist, at least a fellow traveler, and folk were very often afraid to speak up during that time. if lawyers would have spoken up more often, perhaps the political demise of Joseph McCarthy would have come down before it did. It was, to me, of great interest that when I was in the military, I was drafted after college, and then, as it turned out, they asked if I was interested in being in the counterintelligence corps. And I said, sure, that sounds better than being a rifle soldier. And so I said yes, and they said they had special training. At that time, and particularly, I guess, in an outfit like counterintelligence corps, Joseph McCarthy was like their hero because he was anti-communist. At one time, one of the officers was lecturing us, and he started lecturing against those people who believe in civil rights and so on. I couldn't take it anymore. I got up and disagreed with everything that he said, and all my colleagues there kidded me afterwards. They said, well, Cruz, the Korean War was going on. I said, we'll see you in Korea. They were sure that I was going to be kicked out of that intelligence school and sent to Korea right away. I think the officer must have thought I was kidding, because apparently he never reported me, so I graduated from as a counterintelligence corps agent. But those were in many ways dark days. Well, I must say that we look back on those days and we say we were wrong to have placed those restrictions, and those who placed restrictions on themselves were wrong. Then Joseph McCarthy went from hero of the military to the enemy of the military during the time that I was in the counterintelligence corps school. That's when the McCarthy hearings took place, and the famous question to Joseph McCarthy, "Sir, have you no shame?" And suddenly, from his having been a hero to many people in America, they realized what a scoundrel he was, how he accused people of being communists when they were not, how he was doing it for his own self-aggrandizement. And even from the military, he went from being a hero to being an enemy of the military. He had, by that time, even accused the military of being communist. So I was interested in how things can change quickly if folks speak up. And the folks who spoke up in that hearing were lawyers. And it's lawyers, in my way of thinking, that brought us back to our senses. But now we have another crisis, the crisis of 9/11. And I must say that we have to think about how we've responded to other crises. Did we respond the right way in the McCarthy era? I think most observers would say no. Did we respond the right way during the First World War, when we hated Germans and German speaking so much that some states prohibited the teaching of German? And it was customary at that time of school children to cut out of their songbooks any song written by Wagner, because he was a German. This intensity of anti-German feelings, and a case finally went to the Supreme Court, where the Supreme Court ruled that one's language is part of one's ethnicity. And that's one of those substantive due process rights that the government ought not to monkey with. And so in some ways, because it went to the Supreme Court, it ended up okay, but not okay for the young teacher who was arrested on a criminal charge because he taught in the German language. Now every historian looks back and says that wasn't the right thing to do. Did we do the right thing during the Second World War by the imprisonment of the Japanese Americans? And even Congress has passed a statement of apology. All of us agree that we can do the right thing then. So what we have to do, obviously, is to look carefully as to whether or not we can protect our security and our civil rights at the same time. And all too often, folk are willing to say we've got to give up our civil rights to protect our security. Maybe, but history tells us that when we've taken our security, our civil rights away from us, it really hasn't helped that emergency. The Japanese Americans turned out to be loyal Americans. It didn't help us fight the Second World War any better. The German Americans were marvelous Americans. It didn't help us fight the First World War any better. When even a great president like Abraham Lincoln suspended the habeas corpus, all historians agree that didn't help the North fight the Civil War any better. Are we to accept now simply because our leaders tell us that we have to give up our civil rights, must we do so? Maybe, but I suggest that we as lawyers have a duty to look at it carefully. And if we disagree with our leaders, to speak out and to say, I agree with this, I disagree with that. And we as lawyers, as public citizens, I believe, indeed, have that responsibility. I had a meeting with first-year students at the school because I have this chair for the teaching and study of freedom and equality. And what lawyer could say no to a chair like that? So I've been having dinners with first-year students to talk about these issues. And we were talking about some of the restrictions of civil rights. And practically every student disagreed with some of those restrictions. And I thought it was odd that practically every student disagreed, and yet in the political discussions that we have in Washington, so many folks seem to agree with the restrictions. Does it mean that those of us who disagree are not speaking out? If so, I think we have a duty to speak out and then have the people decide based on that exchange of ideas. The great notion that a democracy ideas are to be placed on the table so people can see what they are, discuss them, and then make up their own minds, and not permit simply voices coming from Washington to convince us of one thing to another. And among those, as I say, who have the greatest influence are those who understand the workings of government and the relationship of citizen to government, and those folk are called lawyers. And it seems to me that we as public citizens, we have a responsibility to speak out. Now I must say that I would welcome other ideas about what it means to be a public citizen and to be a lawyer, because that's our ethical responsibility. And I'm told that the folk here, in fact, want me to put my thoughts here, which I have in writing for the law review, and I'll do that. But I would welcome other people's thoughts about what our responsibility is, because I'm influenced clearly by my own background, including obviously what you heard in terms of what I've done in the past. You know, I grew up of immigrant parents. My folks came from Mexico in the 1920s. During very hard times, they came from a portion of Mexico that was said to be more Catholic than the Pope. In fact, there had been a great revolution in Mexico, revolution of 1910 that went on to about 1920, and they got rid of the dictator. But the new government had an anti-cleric ambiance to it. They restricted the number of priests and so on, and the area that my folks came from was so Catholic that there was a counter-revolution against the government. My folks were non-combatants, so they said that the government troops, the federales, would come by and they'd steal a horse in the name of the federal government. And then the local insurgents, who were called cristeros, followers of Christ, the cristeros would come by and they would take a cow in the name of Christ, and they were left with nothing. So they said, we gotta get out of here. So they went north and through Arizona, worked on the railroad, worked their way to California, and ended up there working as a farm worker. My dad was referred to as a trabajador de planta. That means a steady worker. He was a hard worker, so he would get a steady job even during the Depression, which was quite exceptional during that time. And so that's my background. Obviously, that influenced me in terms of how I feel. We lived in a little town called Brea in Orange County. At that time, something like 2,000 or 3,000. Now Orange County has millions of people. And, you know, I grew up before Disneyland existed. Can you imagine? and in those days, there were oranges on orange trees in Orange County. At age 7, we moved to a little rural barrio where only Mexican and Mexican American people lived. We looked for a school. In Brea, there were very few Mexican families, so we spoke only Spanish at home, but out on the sidewalks, we fought in English, we played in English, we read comic books in English, and so we really grew up bilingually. And I remember, actually, I know that my English was pretty good, because in the first grade, a teacher was helping a little girl read a book. And apparently I improperly butted in when the little girl couldn't read a word, and I read it for her. The teacher got mad at me and sent me to see the principal. Well, I was terrified of going to see the principal. I was a first grade kid. So instead of going to see the principal, I went outside to the outside stairs and sat on those stairs all day long and never went to see the principal. When my buddy came out at the end of the day, we ran home as quickly as we could. The next day I went to school and the teacher didn't say anything. I think she thought I wanted to see the principal. But anyway, so I know that I was pretty bilingual. Nonetheless, when we moved to Alta Vista, we looked for a school, and we found a place that looked like a school. It was 2 stories, brick, playground, and we tried to sign up, and they said, no, you don't go to this school, you go to Wilson School. So we went to Wilson School, and Wilson School was a school with some wooden buildings, not very impressive, and we noticed that everybody there was Spanish-speaking, Chicanos and Mexican-Americans, and we said, why are we being sent to this school? And he said, well, you're being sent to this school to learn English. Well, we were moderately suspicious that maybe that wasn't the reason, since we knew English already. And then, of course, we discovered that we were attending a segregated school because California at that time had segregated schools when there were a great number of Chicano or Mexican-American families. Not in a place like Brea, because there were too few, but in a place like La Habra, where there were more, they were segregated. And segregation, I learned, was not a good way to have public schools or to have a society. We very much developed a they and us attitude. I recall that a minister from our barrio moved to an Anglo part of town. And in California, you divide folk ethnically and racially. We've got Asian Americans, blacks, Chicanos, and everybody else is Anglo. I was telling the judge and his wife that I was once interviewed by the then chair of the Equal Employment Opportunity Commission. He was offering me a job, and he was Jewish. And at one point he says, you mean that in California, I'm an Anglo, a good Jewish boy? And I said, sorry, sir, but in California, we refer to as an Anglo. So anyway, we were in a segregated situation, which really developed that attitude. And when this minister moved into town, I remember we children talked about it, and we were afraid that they would be attacked physically. In fact, they were not, but that gives you a sense of how much in our community was they and us. We Latinos, we Chicanos, they the Anglos. It was not a good system. So later, when I was in high school, I talked to the superintendent, and he in turn got together or asked to get together with a group of parents from the barrios, and eventually the school was desegregated. This was in the 1940s. And what impressed me was that the board had said they were fearful there would be violence if they integrated the schools. But when they called a meeting to announce what they were going to do, the audience was about half Anglo and half Latino, and when they announced that they were desegregating the schools, the audience burst into applause. And I remember thinking to myself, the people are ahead of the elected officials. Here they're still afraid that there'll be violence and all that. The community, particularly after the Second World War, where men and women had lost their lives fighting for democracy, the soldiers came back and they wanted democracy in their own homes. And so I was pleased to see that reaction. Then, as a kid, as you might guess, influenced by one's family. During the Depression, there were people now called homeless, then called hobos. And somehow we got more than our share of hobos coming to our house. I read some articles later that said that during the Depression, hobos had signals and ways of indicating which houses were friendly to feed them. So maybe we must have been one of those houses, because we got a lot of hobos. And my mom would always put out this great meal for them. You know, tortillas, carnitas, frijoles, arroz. I mean, it was a feast. And we would complain to her that she fed the hobos better than she fed us. And she wouldn't deny it. She would say, we're lucky that during the Depression, you have a father that's working full-time, and we have a duty to share with others who have less than we do. Now, always remember that. And my dad, in some ways, would say somewhat the same thing. We really learned about the dignity of hard work from my dad. But he also always used to say, we ought to recognize that we are all children of God. He says, you notice how when dogs first meet one another, they have a way of recognizing they belong to the same family. If dogs can do it, why can't we, as human beings, recognize that we all belong to the same family? But you know, even then I saw some of the injustices. Not only of segregation, but the barrios were not well served. Sometimes folk were arrested when they shouldn't have been arrested. And then I saw the legal profession. My mom and dad looked for a lawyer one time. They couldn't find a lawyer any place that spoke Spanish in Orange County. And in fact, my dad then told me that he normally depended on the local court interpreter for his legal advice. And maybe that's one of the things that influenced me to give up my promising career as an artist and become a lawyer. Because it seemed to me that folk, to get justice, in fact, need lawyers that they can feel comfortable with. And that's not, I don't want to be misunderstood, that's not at all to say that only black lawyers can serve black people, or only white lawyers can serve white people. Not true, lawyers can serve anybody. But the public as a whole deserves to have in the bar lawyers of all races, all ethnicities, so that they can find a lawyer with whom they really feel comfortable, so that that lawyer can represent their best interests. And I was determined that that's one of the things that I should do. And I must say that I have been indeed blessed, it seems to me, in that profession. So I must end by telling you that I've always been interested in a speech that Abraham Lincoln delivered, where he said that he understood that the Constitution recognized the reality of slavery. He says, I understand that. But the Constitution within it also had those high ideals of equality and freedom. And he referred to those as the standard maxim, the ideal toward which we ought to aim. And he said, while the Constitution recognized the reality of slavery, we have a duty to work day in and day out to bring the Constitution and the American people to its closest ideals, the ideals of freedom and equality that obviously is contrary to slavery. And I think that we, as lawyers, indeed, by being public citizens, have the opportunity to work day in and day out to make sure that tomorrow approximates a little bit closer the ideals that we have for all of us. Thank you very much.
Justice Reynoso has graciously agreed to answer a few questions, if we have some questions. No, I'll let you.
I think the reason you got so much applause just now, I looked back and forth and saw some blank faces. I thought you might be getting kind of discouraged. But you got that applause again was genuine. And I think I'm sort of a recent graduate of law school. My brother's been a lawyer for 20 years. I think it's sort of unusual to meet a lawyer who's just sort of noticeably happy.
I always considered a privilege to be a lawyer. I enjoyed being a lawyer. I used to tell when I started practicing law that I'm being paid for the things I would do if I weren't being paid. And I was always able to feed my family. I wasn't looking to become a millionaire, but I always had enough money to feed the family, and I was able to be my own boss, to be independent. And I've been fortunate, I guess, in my life to be a lawyer, where you can be independent, to be a law professor, particularly a tenured law professor, where you can really be independent, to be a judge, where you're independent. Each position has certain constraints, right? But you accept those, but within those constraints, you're free to do what is the right thing to do. And I think that I lament it when I see young lawyers, because of the law firm that they join or whatever, they're giving up that freedom. I hadn't been a lawyer for more than a few months when there was a strike in Imperial County by farm workers. That's before Cesar Chavez started organizing. Cesar, as I said, was a staff person with a CSO, and he would come down to Imperial Valley and help register people, conduct classes and all that. And incidentally, he didn't like unions. People nowadays think he was a union person all his life. He was quite suspicious of unions because the AFL-CIO Farm Worker Organizing Committee had tried to organize farm workers. They would call a strike, it would not succeed, the organizers would leave, and the farm workers were left to suffer. So he, at first, was quite suspicious of unions. But in the CSO, he learned to organize farm workers because of the Bracero program, where the Bracero program said that you could bring in foreign workers, mainly Mexican workers, to work in the fields if local workers could not be found. And there were many unemployed farm workers, and he would gather them and go and offer their services to growers, and growers would say, sorry, we've got Braceros. So he started organizing farm workers. But I started to tell you this strike was called before Cesar Chavez started organizing farm workers. And the lawyers who were representing the AFL-CIO called me to go, well, we had a judge there who was a wonderful judge, but he hadn't kept up with the Constitution for about the last 50 years. And he ordered all picketing to stop, not to be peaceful, not to be every 10 feet. He ordered all picketing to stop. Well, you know, the picketers, they didn't stop. He ordered them all arrested. So they were all arrested and taken to the tank, the jail tank. At that time, there was a rule that said that only jailers and lawyers can enter the tank. Why they put us in the same category, I never understood, but that was the rule. So they called me because I was the only native Spanish-speaking lawyer in town, and all the workers were Spanish-speaking, many of them monolingual Spanish-speaking. So they asked me to go see them, not to represent them, but just to get a report on who they needed to contact, medical attention, and so on. I thought it was a mission of mercy. I went to see them, I reported to the lawyers, I went back to my office, which was only a block away from the jail. My two partners at that time were very concerned that I had gone to the jail to meet with those workers. They said, our clients are going to think that we're taking sides on an economic battle here in Imperial County. I remember telling myself, you know, it's a lucky thing that I have a little card that says attorney at law. Because this was simply a mission of mercy. If they become that unhappy with me, I can simply go across the street and set up my own office. Fortunately, I guess they weren't that disturbed because I stayed with them for a little while longer. But I remember the sense of empowerment that I had, that by golly, if they became unhappy with me, I would continue my profession. To have lawyers give up that freedom, if they do, is very sad. I think that's one of the greatest things we can have. And if you have freedom, you've got happiness, and that's why I'm happy.
You were one of 3 California State Supreme Court justices recalled because of your supposed opposition to the death penalty at that time, which you denied. You said that you didn't necessarily oppose the death penalty, it was how it was opposed to.
Yes.
Has your thinking changed any on that score over the intervening years, particularly in light of all the resolutions that have been made?
No, I hate to say that I'm such a conservative person that I don't think I've changed many of my views since I was a teenager. And with respect to, first of all, it wasn't a recall, as you know, it's a confirmation vote. In California, appellate trial court judges are appointed by the governor, then they have to run for re-election. Appellate court judges are appointed by the governor, and then they come before the voters on a yes-no vote. It's called a confirmation vote. I had been appointed to the Court of Appeal, and I was confirmed by the voters. Then I was appointed to the Supreme Court, and I was confirmed by the voters again. Then there was a long, intensive, and quite brutal campaign against our Chief Justice, Rose Berg, who was the first woman to sit on that court. And I think there was a lot of resentment that a woman had been named to the court, and she had been a public defender. So she was attacked as being soft on crime. And then a campaign to urge a no vote against the Chief Justice evolved, eventually led by the governor of the state, Governor Boocheever. Sad to say, many people who are in public office are adverse to controversy, believe it or not. So basically the Republicans were attacking the Chief Justice, the Democrats hated to get into the fray, so they were saying nothing. So this was a constant attack that went on for several years. The polls indicated that they in fact were going to be able to defeat the Chief Justice. And so they said, hey, if we can defeat the Chief Justice, why don't we go after a couple of other judges? And so they added Justice Groden and me to that list. And they succeeded. They spent something like $12 billion in the anti-court campaign. My own views on the death penalty have not changed. That is, I do not have a moral objection to the death penalty. I can conceive that under some circumstances, the death penalty is the only way in which a society can protect itself. For example, if you have a small community that has a person who has killed people, and for example, they don't have facilities to keep that person in prison for life, it seems to me that society has to have a right to protect itself. So on a moral ground, in fact, if I had a moral objection to the death penalty, I would not have accepted the position of the Supreme Court, because we have had a constitutional amendment to the Constitution of California permitting the death penalty. So I would not have accepted that position. I've talked to friends of mine who are morally opposed to the death penalty, and they said I could not accept that position. Nonetheless, I've always been bothered by the death penalty and whether or not it can be applied evenly and fairly. And that just doesn't start with the judges, it starts with the prosecutors and so on. Example, in Northern California near Chico, a few years ago, there were two young white men who shot a young black man to death. Nobody knew who had shot that young black man who was just walking down some railroads, and all of a sudden he was shot dead. These two young men apparently bragged to their friends, and so word got back to the police that they had shot this man. Their story was that they had gone deer hunting and couldn't find any deer. And they were so mad that they said, why don't we just shoot a nigger? They found one and they shot him dead. A press conference was held, they admitted everything. A press conference was held by the district attorney later on and said that they had entered into an agreement where they would plead guilty and be sentenced to life imprisonment. A reporter said, why are you doing that? Such a terrible crime. Why did you ask for the death penalty? His response was, I don't believe that a jury in this county would send a white man to death row for killing a black man. He might have been right. It may have been the right thing for the DA to do. But so often we see incidents like that where you ask yourself the question, is the death penalty really being applied properly? So my view as a judge was that we should be very careful with each case. And the case law in California said that death is different than other criminal cases. If you make a mistake, you can't undo it. And so that's the philosophy that I had. During the time that I was in the court, I voted more often to overturn the death penalty than to affirm it. But that had to do with what was happening in California at that time. We had an initiative called the Briggs Initiative, sponsored by a state senator who was hoping to run for governor. He did run for governor. And he bragged that his initiative was tougher than what the Supreme Court had said you needed to have a death penalty. He was right, it happened to be unconstitutional. The legislature had actually passed a death penalty statute that was constitutional, but then there was a vote on the initiative and the initiative passed. And the law in California was that a constitutional change trumps a statute, obviously. So that became the law of the land in California. But it clearly violated several of the mandates that the U.S. Supreme Court had said in the second time around on the death penalty. As you recall, they had declared the death penalty unconstitutional. Then there's another case where they said, well, it can be constitutional, but you've got to follow this criteria. The initiative did not follow the criteria. So it's logical that when the cases finally got to the Supreme Court, we would overturn the cases where it didn't meet the criteria. And I used to tell people that with time, we would have affirmed a lot more cases. I think I voted to affirm 3 or 4 death penalty cases during the time that I was in the court. And so that's what was happening at that time. Meanwhile, as you might guess, the politicians, including the governor, were accusing the court of letting criminals out on the street and so on. All those folk had been convicted of first-degree murder. They were going to be in prison for at least their entire life. None were to be freed. What we were doing was overturning the second. In a death penalty case, you've got to have 2 trials. The first trial is, did the defendant commit the crime? The second trial is, should that defendant be sentenced to life imprisonment for life without the possibility of parole or death? We would overturn the second part of the trial because we hadn't followed the Supreme Court mandate, and only that part would be tried. So the people of California were perfectly safe. So it was a campaign urging a no vote. One might guess has to be a negative campaign. So it was really a brutal, untruthful campaign against the Chief Justice. And at the last 2 weeks, they picked up on Grodin and me, and they had a very clever television advertisements that basically said, if you don't like Roseburg, you can't like Reynoso and Grodin, and they succeeded in a negative vote. So that's why I left the court. Incidentally, though, it was a great experience to be on the court. I was very pleased to have been honored by the governor and the people of California. I understood, at least I took that not to be a personal defeat or a professional defeat. I took it to be a political defeat. And I wanted folk, particularly the governor and others who had succeeded in that case, to understand that it was only a political defeat. So fortunately, in the last few months of the campaign, I had hired a political consultant. You know, most of the friends of the court didn't know what to do. What do you do when you're being attacked? Judges don't always go out and appoint political committees and start gathering money and all that. Nonetheless, once the campaign got going, we did a little bit of that. We got enough money to hire a political consultant. We didn't do too much, but he did take those polls that consultants take before a vote. And about a week or two before the vote, he said, Cruz, you're going to lose. I remember I told my colleague, Rose knew that she was going to lose, but I told Joe Grodin. Joe says, I'm sorry, my consultant wants these polls, and he tells us that we're going to lose. He couldn't believe it. My friends called, and they wanted to get a big room the way they do in campaigns, to have a celebration on the day of the election. Said, I'm going to watch TV alone, I said. And then I forewarned my family about what was going to happen and my closest friends. And so it was no shock to me. I decided to take the next day off. It was one of the nicest days I've ever had. My wife and I went up to the foothills, the Gold Country. We visited a museum that opens only once a week. We had lunch. We returned. I didn't want to bother with the press. So the next day I started returning all these press calls, and they said, gee, Cruz, we heard you were so devastated you went incommunicado for a day. I said, hey, after all this, I wanted a day off. So I always just considered it a political defeat. I wanted to land on my feet. So I got a job with a law firm, paid me a lot more money than I was earning as a justice, and I started to work as soon as I left the court. And then I could do the things that I couldn't do as a judge. I could speak to public issues and so on. So to me, it was a sad day for California, but we judges, of course, landed on our feet.
Thanks again to Justice Reynoso, and thank you all for coming. I can't let the evening go past without thanking the person who really organized all of this, Beth Wilkins, my wonderful assistant, who's somewhere. There you are. Oh, you were back there before. Thank you, Beth. And yes.
Sorry to interrupt, but I want to thank Beth and her husband who came out and met me at the airport.
I also just want to take 1 minute to invite you all to come to the Coffin lecture next year, which is on October 16th, again a Thursday evening, when our 12th Coffin lecturer will be Scott Harshbarger, who's currently president of Common Cause, former Massachusetts Attorney General, and many other things about which you'll learn next year. So thank you all for coming.